mission of the said second appeal.
Right.
I'm for the appellant petition.
Yes, sir. What is that?
My lord, all corrections made, my lord.
Wait,
Pursuant to
wait.
your lordship's directions.
Out
my
of
lord.
time, only section 5 has been served.
Section 5, my lord, yes.
You are for the
Yes,
Oh,
I'm
yes,
waiting
that.
for the respondents, my lord.
What is the delay?
My lord, delays of my lord 1 year, 2 months. Now, my lord, for the 2 months, my lord, section 14, my lord, of the limitation act, my lord, I'll plead, my lord, since a revision was filed initially, that was my lord
It's the
subsequent.
impugned judgment.
Order 22, Rule 10, my lord, that has been allowed.
Yes, we are allowing. What is this addition of party? Who do you want to add?
Addition of party, my lord, I'll just come, my lord, addition of party, because, my lord, initially in the memorandum of appeal, my lord, the name of Sekhar Das was, my lord, my lord, my lord,
Yes.
inadvertently, my lord, made in the cause title. Sekhar Das, my lord, died, my lord, during pendency of the, my lord, the suit, and my lord,
His heirs were substituted there.
substituted there.
You are permitting both these applications, allowing.
My lord, but I should, my lord, oppose, my lord, considering the delay and my lord, without any
Why
absence of-
should you should? You are opposing. You are recording your opposition and allowing. Can 1 of 2025 is an application for addition of the heirs and legal representatives of one Sekhar Das who had expired during pendency of the appeal before the first appellate court and his heirs had already been substituted. Full stop. Next para. Since the application is technical in nature and comma in any event comma the heirs of the deceased have already been substituted in the first appellate court comma can 1 of 2025 is allowed, thereby directing the heirs and legal representatives of late Sekhar Das to be added as parties to the present appeal instead of the said deceased, who sub necessary consequential corrections to the cause title of the memorandum of appeal and the pending application comma if any shall be carried out by the learned advocate and record for the appellant during the course of the day this time.
Yes, yes.
In the course of the day. Full stop. Next para. Can 2 of 2025 is an application for condonation of delay. Full stop. The present appeal challenges an order passed under Order 22 Rule 10 of the Code of Civil Procedure. Full stop. Initially, comma, a revisional application was erroneously filed. Full stop. However, comma, subsequently the error was detected. It was dismissed.
My lord, withdrawn.
Subsequently, the error was detected and the said revisional application was withdrawn and the present appeal preferred on proper legal advice. Full stop. We find sufficient bona fides behind such error, comma, since it might omit the notice of the learned advocate, comma, if not regularly conversant with civil law as to the availability of an appeal against an order under Order 22 Rule 10 of the Code of Civil Procedure under Order 43 of the said code. Full stop. Next para. Accordingly, we are of the opinion that sufficient reasons for the delay has been made out. Hence, can 2 of 2025 is allowed on contest, thereby condoning the delay in preferring FMAT 373 of 2025. Now, move the appeal under Order 41.
Yes. My lord, initially, my lord, the plaintiff, my lord, is my lord, one Sankar Das. He filed a suit for partition against my lord 3 defendants.
Yes.
Sekhar, Somnath, and Minoti. Now, my lord, Minoti is the mother. Minoti is the mother. Sekhar and Somnath are 2 of his brothers. Now, my lord, that suit, my lord, 1/4 share, my lord.
Santadas is not corrected here.
Yes, Shanti is corrected, my lord.
Where? In the memo, it's not there. Still not corrected.
My lord, in the memorandum, my lord, it was, my lord, wrong. My lord, I just now I moved the application for addition of party. Now it has to be, my lord, added.
Oh, that's Sekhar.
Sekhar one. First Sekhar.
Yes. Please carry on.
Yes. Now, my
What
lord,
is the suit for? Who filed the
suit
suit?
for partition?
Partition.
My lord, filed by, my lord, one Sankar. Now, my lord, Sankar died, my lord, during, my lord, after, my lord, the preliminary decree was passed. 1/4 share was, my lord, pleaded. 1/4 share for Sankar, 2 of his brothers, and the mother. My lord, suit initially preliminary decreed. After that, my lord, for final decree, application was filed. It's in the process, my lord, for final decree. In the meantime, the mother died. The mother
Also died, mother also died.
Mother also died.
Both died after preliminary decree.
After preliminary decree.
Right? Mother's name?
Mother's name is, my lord, Minoti.
Minoti died. Sankar both died. Yes. Then what happened?
Minoti died on 4th of March 2022.
So who are sought to be added now?
Not added. Well, what happened is, at that point of time, Sekhar and Somnath came up with an application under Order 22 Rule 10 stating that the mother already gifted us her share of the property prior to, my lord, filing of the suit itself. Suit was filed on 7th of July 2011. They came up with an application that the deed was made on 24th of May 2011.
In the written statement, they did not disclose.
Nothing disclosed. Minoti, my lord, Cross-examination
But
happened.
if it's a registered deed, you have to challenge the veracity of the deed also. Otherwise, this cannot be decided at Order 20 Rule 10 stage. It can be tentatively decided that since they have a registered gift deed, the heirs, see, Order 20 Rule 10, they are already parties.
Already parties. 152 I filed for my lord correction of the decree since initially I pleaded share
So
for
they are
1
already
crore.
parties. So now they basically seek to exclude the other heirs.
Exclude the other as so far as Minoti share is concerned.
Minoti and no, not Minoti.
Minoti share is concerned because they say Minoti gifted us her share of the property prior to my lord the suit itself. My lord, kindly my lord takes up their application once, my lord.
First, we'll see the order, Mr. Banerjee, and then we'll go back
Yes,
to
yes,
the
yes, certainly, my lord.
That will make it
You'll
clear
also be
for us.
taking up the stay application. I have
No,
annexed.
the memorandum itself. So, what is the number of the order? Date of the order?
Order dated, my lord,
28th June.
28th June
20th of
2024.
June 2024, my lord.
Let us read that order. Please place that, Mr. Banerjee.
Yes, yes, just my lord. 28th of June, my lord, order number 105. My lord, both the parties file their hajira. The petition under order 22 rule 10 of CPC is taken upon record for hearing in presence of both the parties. Peruse the petition, heard both the sides. At the time of hearing, learned lawyer of the plaintiff has submitted that the provision of order 22 rule 10 of CPC has come
Okay,
into
very
play.
good. Now, see, you have two grounds, two very good grounds. One is that this happened. Apparently, the gift deeds were executed in 2011 prior to filing of the suit even.
Institution of the suit itself.
So therefore, they did not take this point. They're precluded.
Did not take these points in their in their written statement, in their cross-examination ever.
Before the shares, the preliminary degree has attained finality now.
Yes.
Now they cannot reopen those shares.
Reopen the shares after I file a 152 in terms of that Minoti diet. So
Secondly, another ground is probably there because they're already parties. Order 20 Rule 10
Rule
was
10
a
does not apply at all.
superfluity.
Does not apply.
Yes, we'll ask you, why Order 20 Rule 10? If you rely on a gift deed, two questions to you. One, if you rely on a gift deed which was executed in 2011, why don't you disclose it before the preliminary degree is passed and the shares are declared? Once the shares are declared, they cannot be reopened because preliminary decree has equal binding effect as a final degree. It's a degree of court. If that be so, you are in effect trying to reopen the preliminary degree without preferring a challenge to that. One. Secondly, why this sanctifying or validating your stand by allowing an Order 20 Rule 10? Order 22 Rule 10 is applicable when somebody steps into the shoes of a party. Here you are already parties. This order will set aside, will permit you to produce the gift deed if otherwise permissible in law, subject to their objection in the suit.
Now,
But will also hold that this is a good ground for their resisting, that you are in effect. And why should we permit you at all? This Order 20 Rule 10 was a superfluity one. Second, the deed was executed prior to the filing of the suit. So you cannot reopen the preliminary degree without preferring a challenge. Therefore, you cannot produce the deed even. We cannot give you that liberty also.
Now, my lord, may I submit, my lord? My lord, the
only my lord, one thing, my lord, may I place, my lord, the application itself, my lord. Kindly, my lord.
What to do? What is the worst thing in the application? Tell us.
Worst thing, my lord, the only thing in the application is it was kept in a locker. I missed it. Whereas, my lord, the gift deed is in favor of both
Happens
the
every
brothers.
time to me. Maybe a truth. Maybe the truth. If you look at the application, you will be convinced.
My lord, lack of knowledge cannot be a ground.
Something is always kept in some almirah, some locker.
Yes,
What
my lord,
happened during demonetization?
This is not a will.
Your monies which were given by your mother in your birthday and you kept it in an exercise.
It happened mostly with the mothers.
No, not children also. Yes.
Yes, my lord. My lord, kindly consider this Rule 22, Order 22 Rule
Forget
10.
the provision. What is your answer to our
Well,
question?
I'm saying, my lord, I'm saying, my lord. My lord, the simple reading of the Order 22 Rule 10,
What does it say?
start with, my lord, procedure in case of assignment before final order in suit. My lord, it is a procedural, my lord, provision. While it is a procedural provision of the trial court, it is also a discretionary power of the trial court. It is not a restrictive in nature, kindly consider. This, my lord, in consonance with, my lord, Order 1, Rule 10, for proper implement of the parties. Now, my lord, my substantial right has to be established there. Otherwise, my lord, it will bring another, my lord, multiplicity of suit, because, my lord, I have to file another suit for declaration to get the right from the, my lord, deed of gift. Kindly consider. Next, my lord, this is not a final order at all. This is not a final order at all, my lord. My lord, by this impugned order, My lord, court given a chance to us to decide the matter. It is not, I said earlier, my lord, it is not final order. And my lord, no prejudice caused to my learned friend or their client in respect to share. And my lord, kindly consider as per section 122, 123 of the Transfer Property Act, a gift deed is final, valid, and complete when it is executed. They know about
It is not. That is the fun of 122, 123. It
120.
is not when it is executed. When it is accepted during the lifetime of the donor.
Yes, my lord.
That is the difference between
And my lord,
transfers
they
and gift deed.
and my lord, they know the execution of the same. They know well about the gift deed. Till that, I am submitting before my lord, they have not challenged the said gift deed. That means they admitted it. My lord, the order 22, rule 1, my lord know better than me. The Supreme Apex Court, my lord, said it can be invoked if the situation so demanded. My lord, I can here and now show and order judgment of the Supreme Court. Kindly go, do not go. One thing, another, my lord. This order 22, rule 10, while, my lord, it is empowering under the discretionary power of the trial court, while it is empowering the trial court to bring the lease pendants transfer or transferees into the picture, it
Not a lease pendants transfer.
yes, my lord, I'm
Pre-litigation transfer.
yes, my lord.
What is
Now, my lord, it is all this power, this rule also empower the trial court to bring the pre-suit, my lord, transfer and transferees. Because, my lord, real owner and substantial right has to be established
Let us read order 22.
in consonance with.
Let us read order 22 rule 10 together.
It is said, my lord, during the pendency.
Let us read order 22 rule 10 together. That will help all of us to understand the law.
Procedure in case.
Yes.
Procedure in case of assignment before final order in suit. Before final order. Procedural. In other cases of assignment, creation or devolution of any interest during the pendency of a suit,
What does the meaning?
during the pendency of the suit. But my lord, in consonance with the order 1, rule 10, proper implement of the party and to establish the substantial right and to avoid the multiplicity of the proceedings, my lord, this or impugned order is justified because it is not final at all. This order is not final at all, and the apex court, my lord, in a judgment, the judgment may differ, my lord, factually, because in this judgment which I am relying, it is, my lord, relating to, my lord, lease pendant suit. But the observation of the Supreme Court, my lord, in this, kindly see, my lord, page 125, my lord.
Page 125 or what?
In a
The book
shorter-
of nature.
Yes, my lord.
Give the citation.
Citation by 2013, volume 5, Supreme
You have
Court.
got
Case.
one copy before a division.
My lord, extremely sorry, my lord. Within a short time, I can.
Give the citation. What is the citation? 2020,
2013, volume 5, SCC 397.
Which paragraph?
My lord, paragraph I want to rely 54.
Read it out, please.
In 54, my lord, the rule order 10, order 22, rule 10 has been, my lord, stated here. A simple reading of the above provision would show that in case of assignment, creation, or devolution of any interest during the pendency of the suit may, by the leave of the court, be continued or against the person to or upon whom such interest has come or devolved. What has troubled us is whether independent of order 1, rule 10 CPC, the prayer for addition made by the appellant could be considered in the light of the above provision, and if so, whether the appellant could be added as a party respondent to the suit. Our answer is in affirmative. It is true that the application which appellant made was under order 1, rule 10 of the CPC, but enabling provision of 22, order 22, rule 10 could always be invoked if the fact situation so demanded. I want to rely on this, my lord, observation that, my lord, to bring the substantial right of the parties, as it is not a final order, to, my lord, bring the proper implement of the necessary parties in consonance with the order 1, rule 10, my lord. This order is valid, and since it is a, my lord, discretionary power, this should not be generally interfered with, my lord. It is a procedural law.
Who are the applicants there? 1 and 2.
1 and 2.
Sekhar and Somnath.
Sekhar and Somnath.
Sekhar has now died.
Sekhar has now died. Now died.
Yes, we are allowing the appeal. We'll record your submission.
Kindly.
In view of in view of arguable questions of law and fact being involved, we admit the appeal and hear it on the grounds taken in the memorandum. Push up next para. Since the ambit of the appeal is brief, comma, we take up the appeal itself for hearing. Upon hearing both sides. Push up next para. In a suit for partition, comma, after the passing of a preliminary decree, comma, two of the parties to the said suit, namely one Shekhar, within bracket since deceased, bracket closed, and one Somnath, comma, took out an application under Order 22, Rule 10 of the Code of Civil Procedure, alleging that their mother, comma, one of the parties to the suit, comma, executed a deed of gift in the year 2011, comma, that is prior to filing of the suit in 2013, comma, thereby donating her entire share in favor of the said Shekhar and Somnath. Full sub next para, by the impugned order, comma, the same was allowed. Full sub next para, learned counsel for the appellant argues that by allowing the said application, comma, the learned trial judge has given a premium to the applicants, that is Shekhar and Somnath, despite them having not pleaded or brought on record the said gift deed throughout the pendency of the suit till the passing of the preliminary decree. Full stop next para. As such, comma, it is argued that there was no occasion for the learned trial judge to permit such gift deed to be brought on record and or, comma, on the basis of it, comma, to go against the grain of the defense taken in the suit and permit an application under Order 22, Rule 10 of the Code. For some next para, it is further argued that there was no occasion for allowing an application under Order 22, Rule 10 of the Code, comma, since the two applicants therein were already parties in the suit and their right, title, and shares have already been decided in respect of the property by way of the preliminary decree. For sub next para, learned counsel appearing for the respondents one series within bracket as substituted bracket closed and two, comma, that is Shekhar within bracket through his heirs bracket closed and Somnath, comma, submits that the power vested under Order 22, Rule 10 of the Code of Civil Procedure on the court is discretionary and must be exercised for the ends of justice if the fact situation so demands. Full stop. In support of such submission, comma, learned counsel cites নামটা একটু দেখে করে দিও ওই নেট থেকে 2013 reported at 2013 5 SCC 397 where the Honorable Supreme Court held inter alia, comma, that in the facts of the case, comma, a lease pendants transferee was required to be added as party to the suit, comma, under the enabling provision of Order 22, Rule 10 of the Code, comma, even if the application for addition was filed under Order 1, Rule 10. Full sub next para. Learned counsel for the respondent numbers 1 and 2, 1 series and 2, next argues that the right of a party is required to be established, comma, particularly in the conspectus of a partition suit, where the respective shares of the parties are required to be allotted. Full stop next para. Thirdly, it is argued that an order passed under Order 22, Rule 10 does not conclusively determine the title of the parties, and as such, there is no scope of interference by this court with the impugned order. So next para, certain facets of the matter, and upon hearing learned counsel for the parties, comma, we opine as follows, colon, next para, certain facets of the matter cannot be lost sight of. Full stop next para. First, comma, in a partition suit, comma, by way of the preliminary decree, comma, the title as well as the respective shares of the parties are conclusively determines. Full stop. A preliminary decree is as conclusive as a final decree within the definition of Section 2 of the Code of Civil Procedure and has conclusive and binding effect on the parties. Full stop. Next para, by dint of introducing the existence of a purported gift deed which was executed prior to the execution of the suit, comma, by way of the application under Order 22, Rule 10 of the Code of Civil Procedure, comma, the applicants therein now seek to reverse stroke modify the preliminary decree, comma, which has already attained finality, comma, for all practical purposes. Full stop. In the absence of a challenge to the the preliminary decree, comma, such an introduction and or modification of the decree in the garb of an order under Order 22 Rule 10 is not permissible in law. Full stop. Next para. It is also important to note that Order 22 Rule 10 of the Code of Civil Procedure contemplates only the devolution of a right lis pendens, that is, during pendency of the suit, and not pre-suit passage of title. Full stop. In the present case, comma, the 2011 gift deed, which was purportedly executed in favor of the applicants in the Order 22 Rule 10 application, was executed even prior to the filing of the suit. Full stop. In view of the defendants stroke applicants having not pleaded about the said gift deed and or produced the deed throughout the pendency of the suit till the passing of the preliminary decree, comma, they are now precluded from relying on the same. Full stop. Next para. Since the preliminary decree has since attained finality in the absence of any challenge thereto, comma, the applicants in the Order 22 Rule 10 application could not have been permitted to reopen the same at this juncture on the strength of a purported pre-suit deed. Full stop. Next para. Thirdly, comma, the judgment cited by the respondent number 1 series and 2 is not apt in the context of the present case, comma, since the Supreme Court was considering a lis pendens transfer therein, and the ambit of the consideration was whether, comma, if an application for addition of parties filed under Order 1 Rule 10 of the Code of Civil Procedure, but in effect, comma, the uh, paradigm of Order 22 Rule 10 is applicable, comma, such application should be allowing by by invoking the provisions of Order 22 Rule 10, comma, which is an enabling provision. Full stop. In such context only, comma, the Honorable Supreme Court held in the affirmative. Full stop. Next para. As such, comma, the questions which have arisen for consideration in the present case did not fall for consideration or were decided by the Supreme Court, Honorable Supreme Court, in the said judgment. Full stop. Thus, comma, we do not find any precedentiary value of the said judgment insofar as the present case is concerned. Yes, you were saying, sir?
My lord, kindly record, my lord, regarding assessing the preliminary decree, we have challenged, filed an appeal, my lord, which is still pending, my lord. Kindly, my lord, record.
You all along, please keep it with you. Why didn't you say so long when we were hearing you?
No, I have said, my lord, on the earlier occasion, my lord. But since my lord is recording this, my lord's observation, that's why, my lord. I earlier occasion I prayed to take both the appeal, my lord, and to hear the same, my lord.
যেখানে যেখানে বলেছি has attained finality in the absence of an appeal, ওই জায়গাগুলো একটু বোল্ড করে দিও, অ্যাপিল করেছে। নেক্সট প্যারা, ওখানটা আমি চেঞ্জ করব। নেক্সট প্যারা। Since the respond numbers 1 series and 2 submit that they have already preferred a challenge against the preliminary decree, comma, the ground of existence of the gift deed can very well be canvassed there. Full stop. However, comma, unless such appeal is entertained and allowed, comma, thereby modifying the preliminary decree, comma, the respondent numbers 1 and 2 could not have been permitted by the learned trial judge at the final degree stage of the suit itself, comma, to reopen or modify the preliminary decree by introduction of the gift deed in question. Full stop. Next para. In view of the above, comma, even otherwise, comma, the application under Order 22 Rule 10 of the Code of Civil Procedure was superfluous, comma, since the applicants therein were already parties to the suit. Full stop. Next para. The only purpose of filing the said application was evidently to seek a validation of the deed of gift, which was suppressed all through the pendency of the suit till the filing of the preliminary decree, and thus the said application could not have been permitted, comma, being in essence a mala fide one, comma, seeking to do something which could not be directly done, comma, indirectly. Full stop. In view of the above, comma, FMAT number 373 of 2025 is allowed on contest against the respondent numbers 1 series and 2, and ex parte against the against the pro forma respondents, comma, service upon the latter being dispensed with, since they are not affected by the present order. Full stop. Next para. Accordingly, the impugned order bearing order number 105 dated June 28, 2024, passed by the learned civil judge junior senior division, second court at Chinsura, uh, uh, district Hooghly, in title suit number 625 of 2013, is set aside without any order as to cost. Full stop. Can can which has been 1 and 2 have been allowed already.
1 and 2.
Can 3 of 2025 stands accordingly disposed of as well, no order as to cost. We'll modify those portions where you have said it has attained finality because you have not preferred an appeal. We'll say that you have preferred an
My lord,
appeal.
kindly take the, my lord, appeal number, my lord. It would be
It-
better.
We'll record that you have preferred it. Fine. Next.
Grateful, my lord.
Thank you.
Grateful. my lord.
You argued well. You tried to argue well, but anyway, let us see. Oh, all the best in the appeal.
Grateful. my lord.
Next.